Hi, everyone. Thanks for joining us today for our webinar. For today's session, your microphones have been muted and your cameras are turned off. If you have any questions, please add them at the Q&A icon on the screen, and Elise will be addressing them at the end of her session. We note that Elise is not going to be able to comment on individual cases or provide specific legal advice. So we'd ask that your questions be targeted towards the information that's being presented today. And Elise will provide contact information at the end as well. So on behalf of the OPWA, we'd like to thank everyone for joining us today. My name is Tricia Hamilton, and I'm on the board of the OPWA. The OPWA is an organization of public works professionals. We have around 600 members throughout Ontario, as well as two different branches, the West Central branch, which is in Niagara, and the Ottawa Valley branch. Our mission is to connect the public works community, and so we're happy to have everyone here today to be able to connect everyone through education. This is a session of our Ontario Public Works Connects, which is our monthly webinar series. So we'd ask that you keep your eye out on your emails because we target having these once a month, and they're a great opportunity to learn more about topics of interest to public works professionals. We ask that you visit our website to find out more information about us, the different events that we have ongoing. We're always looking for volunteers for a number of committees as well, if you're interested in getting more active in the public works community. And with that, I'll introduce our speaker today, who is Elise Teitler. Elise is currently the project manager for the Ontario Dispute Adjudication for construction contracts. In her years as a practicing lawyer, she was both a commercial litigator at a downtown Toronto law firm and held positions as in-house counsel for a large television broadcaster and a software company. As a litigator, she appeared in court to litigate corporate commercial matters and worked in the communications area. She has been involved in many settlement negotiations to bring resolutions to various disputes. Elise joined ODACC as project manager in November 2020 and is working on other projects for ADR Chambers. Thank you very much, Elise.
Thank you, Tricia. I'm just going to pull up my screen. Give me a moment. Okay, hopefully that works. Well, good afternoon, everyone, and thank you all for having me. I'm excited to be here and talk to you about adjudication and how it can help you out with your construction contracts and your projects in the years to come, or the months to come, or the weeks to come. As Tricia mentioned, my name is Elise Teitler. I'm the ODACC Project Manager. And ODACC stands for Ontario Dispute Adjudication for Construction Contracts. As you can see on the screen, my website is odacc.ca. I really welcome you all to visit it. It's quite comprehensive. It will give you more of an indication about how you can proceed through an adjudication, how you can start one, how you can respond to one. It's very, very comprehensive. But my job today is to give you that overview and try and simplify that process. But I am reachable through authority@odacc.ca, as Tricia mentioned. And also, I really welcome you to take note of the website as well and take a look at our website. So let's talk about what I'm going to cover with you today. I'm going to talk a little bit about adjudication. I'm going to talk about ODACC's role, what disputes can be adjudicated, the adjudication timelines, how to commence an adjudication, the actual process in terms of commencing one, responding to one, picking your adjudicator. And then I'm going to walk you through our online system, just give you some screenshots and show you how you would proceed if you were to commence or respond to an adjudication. Just going back for a moment and giving you an overview before I start to give you an actual definition and tell you what adjudication is all about. The prompt payment and adjudication provisions came into effect under our Construction Act on October 1, 2019. And during that time, ODACC was appointed as the authorized nominating authority to administer these adjudications. So some of you may or may not know what adjudication is. We've talked, I'm sure you've heard about litigation, going to court, arbitration, mediation. Well, this is another form of alternative dispute resolution where parties can present their dispute to an independent third-party neutral. Both sides will make their arguments, whether it be written or oral or a combination, to this third party, and the third party will render a determination or a decision, which can then be filed with the court. So as I mentioned, October 1, 2019 were the changes from the Construction Act. And during that time period, ODACC was appointed as the authorized nominating authority for all of Ontario. So what we do is we provide administrative support to help facilitate these adjudications. We administer them, it's done online for the most part, very streamlined system, and we're here to support the adjudications. We also train people to become adjudicators. We offer a 2-day training course and additional refresher training. And for those individuals that are interested in applying to become adjudicator, they can apply to ODACC for certification as an adjudicator. So as I mentioned, we certify adjudicators, and then we actually maintain an adjudicator registry. Currently, we have around 66 adjudicators on our registry. You can see that registry by visiting the ODACC website and clicking on Adjudicator Registry, and you will see quite a diverse group of individuals with various backgrounds who are our certified adjudicators. When you search the registry, you will get a history of the individual in terms of their construction-related experience, their professional background, their years of experience, and a whole host of other information. The other role that we have is when parties cannot mutually agree on the adjudicator they wish for their construction-related dispute, we are called upon to appoint an adjudicator from our registry for that specific dispute. Similarly, when the parties and the adjudicator cannot agree on a fee that is to be charged for the dispute, the adjudication, ODACC will be called upon to set the fee for that particular dispute as well. So what disputes can be adjudicated? Well, it's all set out in the Construction Act. I thought I would give you a little taste of the Construction Act. I've set out the actual provision of the Construction Act, which lists off the disputes that can be adjudicated. Without going into depth with it, again, you can see a lot of this information on our website, but we're looking at disputes that are subject to a contract, dealing with valuation of services, dealing with payments under a contract, dealing with notices of non-payments, set off by trustees, payment of holdbacks, Section 6 non-payment of holdback. And the interesting one as well is subsection 7, which talks about any other matter that the parties to the adjudication agree to or that may be prescribed. And again, why I like that section, that is a section that parties can use to bring parties together to help resolve their disputes. Similarly, the same matters can be adjudicated if you're talking about subcontracts and sub-subs and so on. So this section just talks about that the same types of disputes are also able to be adjudicated with respect to subcontracts. An interesting point about adjudication, and I'm looking at the expiry of the adjudication period section, an adjudication cannot be commenced if the notice of adjudication is given after the date the contract or the subcontract is completed, unless the parties agree otherwise. The other point I want to mention is adjudication is really only dealing with a single matter unless the parties agree otherwise. And I'm stepping back and trying to give a framework. The whole purpose with adjudication is to resolve disputes quickly, efficiently, while the project is running, so the business can continue, the project can continue, and things are not at a standstill. So that flavor is really seen in these provisions. And just looking at subsection 5, these are interim processes. What does that mean? Well, there may be a court case, there may be an arbitration. Parties may wish to arbitrate or litigate afterwards. This is an interim process, and I'm going to speak about it more a little bit later on. This is an interim process or an interim decision unless and until there is a court decision or an arbitral decision that decides the case otherwise. What we are finding is most parties are going into adjudication, getting a decision, living with their decision, and moving on. And that really is the purpose of keeping things moving on and not sitting in court for years and having an arbitration go on for months and years as well. That is really the purpose behind adjudication. So what are the benefits of adjudication, which I just sort of touched on? It's available as right. You don't have to get the other side's consent to say, hey, do you want to adjudicate? If you have a dispute and you fall within one of the parameters that I listed for disputes that can go to adjudication, you can start an adjudication. It's an interim process, which I just spoke upon, unless and until there's another decision from a court or through arbitration. This is a binding decision for the parties. It's quick. And when I take you through the process, you're going to see just how quick it is. We're talking about a decision within anywhere from 39 to 46 days or perhaps less. It's cost effective. It's relatively inexpensive. And we're going to talk about the adjudication fees. And once you get a determination, that determination, if there's an order for payments to be made, those payments must be made within 10 days. It's also an enforceable decision and can be filed with the court for enforcement purposes. So speaking about the adjudication timeline, a claimant is a party that is going to start a notice of adjudication, and we're going to go through the steps involved with that. But in starting the adjudication through the ODACC system, they're going to go on and commence an adjudication by filling out a notice of adjudication form, which I'm going to show you. Once that is filed, the parties have 4 days to agree on an adjudicator and get the adjudicator to consent to say, yes, I will go ahead and adjudicate your dispute. If the parties cannot agree mutually on a single adjudicator, then the parties can ask ODACC to appoint an adjudicator for their dispute. Once the adjudicator is appointed, whether appointed through ODACC or mutually agreed upon, then the parties are going to sit down with the adjudicator. When I say sit down, I mean a virtual sit down. Most of them are done either by a Zoom or a teleconference, and they're going to talk about setting the fees for the adjudication and the process. The parties will have input in terms of the process, and I'm going to talk to you a little bit about the processes that are involved. And they're also going to have input in terms of the fee. Once that is taken care of and the adjudicator consents and they've agreed to the fee and the process involved in their particular adjudication, the claimant, the party that started the adjudication, has 5 days to submit their documents. They're going to upload those documents on the ODACC system. I'm going to take you through that and you'll see what that looks like. And then the respondent, there isn't a specific date for the respondent's documents in the Construction Act, but the adjudicator is going to in setting the process, they are going to set out the timetable and then speak to the issue of when the respondent's documents are to be filed or uploaded on the system. After the claimant files their documents, the Construction Act tells us that the adjudicator must make a decision 30 days after the claimant files their documents. If a determination is not made within that time frame, the Construction Act says it's of no force and effect. So as you see, it is a tight time frame and a quick turnaround for a determination. ODACC then certifies the decision. We put on a rubber stamp. And again, parties, if they choose, can file that decision with the court for enforcement. So I mentioned a little bit about the initial steps of sitting down with an adjudicator and setting your adjudication fee. What is an adjudication fee? That's the fee that's paid by both parties, the claimant and the respondent. And for the most part, it's equally split between the two parties. And that is the fee that's paid to the adjudicator for doing the adjudication. Again, if there isn't an agreement in their meeting, then the adjudicator will ask ODACC to set the fee. And I will show you how the fee is set and the actual schedule of fees, which we are bound to follow, and how each adjudication, the fee will be set in accordance with the amount in dispute. And I'll show that, that'll come up in the next slide. Just as an aside, there's, aside from that adjudication fee that's split between the parties, for disputes that are greater than $50,000, the claimant, the party initiating the adjudication, has to pay a $500 referral fee that's only payable by the claimant. And where the dispute amount or the amount in dispute is greater than $50,000, there's also a $100 certification fee, which is split equally between the parties. So here are the schedule of fees. These really come into play if the parties cannot agree on adjudication fee to be paid by the parties. If ODACC is asked to set the fee, we will go and we will set the fee in accordance with this table. So for example, where the dispute amount is under $9,999, ODACC will set the adjudication fee at $800. That $800 will be split equally between the parties. So $400 each, a flat fee adjudication. And then there's that HST on top of it. As you see, when we move down the table, when we get over the $50,000 mark, the fees then become set at hourly rates. So $250 an hour for adjudications between $50,000 and $249,999, and so on. And that is the table and the schedule of fees that ODACC will use in setting the adjudication fee. And again, bear in mind, these are the fees that will be equally split between the two parties, unless at the end of the decision, the determination, the adjudicator orders otherwise, which they have a right to do, and the provisions for that are also set out in the Construction Act. I have to say, for the most part, in terms of what we've seen over at ODACC, the fees have been equally split amongst the parties. So where do I get started? I have a dispute, an owner and a contractor dispute, and I'm owed money, and I want to commence an adjudication. How do I get started? The starting point is to go to the ODACC website. That's where you're going to create your account. And the ODACC website, as I mentioned before, is really a great source of information. It's going to help you, walk you through all the various steps of doing your online adjudication from start to finish, and I'm going to show you how it works. We go visit our website, the top right corner, you're going to create an account, logging in, email address, and start there. You will be prompted to create an account. You will log in. You can create an account as a party, or if you have counsel and it's a lawyer that's representing you, then you can both have an account for yourself, and your lawyer can also create an account as a representative. So as you can see on the login, it gives you the two parts to choose from, or the two options, I should say. All right. The system will then start to prompt you to actually create a notice of adjudication. It will give you the actual form. You will click on new case, and you will begin filling in the information for your adjudication case. These are screenshots from the system, and they may be a little difficult to see, smaller, but essentially it's going to walk you through. It's going to ask you whether you're a claimant. It's going to ask you if you're represented. It's going to ask you if you're a contractor. And then it's also going to ask you the type of dispute that you have in terms of the category of the construction dispute. And you can see listed there residential, commercial, transportation, etc. And you can fill in that part of the notice of adjudication. It's also going to ask you to give a brief description of your dispute. What's it all about? And it will also ask you, what's the redress that you're seeking? What is it exactly that you want your adjudicator to order? And again, the system's going to prompt you through all of the requirements for your notice of adjudication. Another interesting part is it's going to ask the claimant to suggest an ODACC adjudication process. And on the next screen, I'm going to show you what that means in terms of various processes, depending on the amount in dispute, the complexity of your case. There's various processes that are suggested by ODACC. They're not engraved in stone, merely suggestions to help you choose a process for your adjudication. And it's also going to ask you to go into the adjudicator registry and suggest or propose an adjudicator that you would like to adjudicate your dispute. So that's also on the notice of adjudication. So as mentioned previously, I talked about these processes on the notice of adjudication. You'll see the respondent's going to be asked to suggest one as well. So on the ODACC website, we provide simply suggested pre-designed processes for adjudication. There's also many adjudications that we've seen that are custom. The parties will sit down with the adjudicator and devise a process that is custom. Maybe it's part written document, part oral. Maybe it's 15 pages or 20, and they customize it for their particular dispute. I'm not going to go through every single process, but I'm just going to give you a bit of an overview to show what the difference in, let's say, from process 1 to process 4 in terms of what's involved in the adjudications. So when we look at process 1 in terms of the method of adjudication, this is writing only. These are going to be for simple disputes. The documents that will be included or that the adjudicator is going to ask for may just be the contract and any invoices. The adjudicator is going to limit the parties to only 2 pages maximum in their submissions. So they're not reams and reams of documents. You may have a $5,000 dispute, a $6,000 dispute. You're not going to want to load up reams of documents, 15 pages, as if you're going to court with affidavits, documents, and what have you. This is a simplified process in writing only, 2 pages. The adjudicator's not going to allow any other documents, so streamline it and get your arguments short and succinct. Again, the adjudicator is going to render a decision, 1 to 2 pages, and the fee for this adjudication is going to be a flat fee of $800. And you saw from our schedule of fees for the under $9,999, it was the flat fee for $800. Now, if we compare that to process 4, the method of adjudication is there's not only writing, but the adjudicator is going to permit the parties to also present orally on Zoom or what other format that they wish. Each party will be allowed a short oral presentation, perhaps 30 minutes each. If it's a custom process, maybe it's longer, maybe it's less. What are the documents we're talking about? Well, the contract must be included, the invoice, if one exists. But if we get down to the party submissions and maybe additional documents, we're now at 10 pages. Maybe this is more of a complex case. Maybe there's more money at stake. So the process 4 is designed for additional documentation. Maybe not an oral hearing. The additional documents that the parties can submit are 25 pages, a 5-page decision, and a $3,000 flat fee. And again, bear in mind, these are just suggestions. And I've seen many adjudications where there's variations on all these suggestions. And that's something to be worked out with the other party and with the adjudicator. So it's really case specific. But again, the idea for this is simplified, quick, and get a decision quick and keep the contract and the project rolling. So the claimants now filed their notice of adjudication. They've put down the respondent's name on the notice of adjudication. The ODACC system is then, once it's filed, will then send out an email to the respondent and it will say, please visit the ODACC system. An adjudication has been commenced against you. And then the respondent will go into the system and be able to respond to the notice of adjudication filed by the claimant. Again, they're going to go through a similar process that the claimant did. They're going to obviously put in response to the details of the dispute and the redress sought. And they're also going to suggest a process, and they're going to suggest an adjudicator. So let's just go through. Again, they're going to select a process 1 to 4 or custom if they wish to propose one. And on the adjudicator selection, they then have an option. The claimant has proposed an adjudicator. So then the respondent can say, you know what, I'm fine with that adjudicator. I agree to the adjudicator proposed by the claimant, or I don't agree and I'd like to propose someone else, which they can do, again, from the adjudicator registry. Or, you know what, I just want ODACC to go ahead and appoint an adjudicator. So once that is done, pardon me, the respondent suggested an adjudicator as opposed to consenting. There can be a little bit of back and forth in terms of choosing. Sometimes that happens, sometimes it's agreed upon right away. But at the end of the day, there ends up being adjudicator on the case, whether it's by mutual agreement or whether it's through ODACC appointing. So we're now at the point, there's an adjudicator on the case. We've got our notice of adjudication filed by the claimant. We have our response filed by the respondent, and the parties have agreed to an adjudicator. And then the system, this is again just a snapshot of the system. And as you can see, there's a dashboard with notifications. So it's going to notify the parties all the steps and all the messages on the system. This will talk about the milestones, the description, what needs to be completed when, with dates, and again, to help the adjudicator and the parties to keep this process rolling along. Couple questions that people ask me quite frequently is what happens if the parties don't agree on adjudicator within the first 4 days? Then the claimant has the option on the ODACC system to simply click a button and say, ODACC, please appoint an adjudicator. And that's going to get the process rolling rather than wait for the respondent. What happens if, as you see, the parties each propose an adjudicator? Will ODACC consider the parties' list of preferred adjudicators when making appointments? So let's say the claimant proposed ABC, and the respondent proposed DEF. ODACC, if we're asked to appoint, we will not appoint either one of the proposed adjudicators, but we will appoint someone else. What if I have a contract or a subcontract which purports to actually name an adjudicator for an adjudication? May I use that adjudicator that's listed in my contract or subcontract? No, you're not permitted to. The adjudicator must be a certified adjudicator that comes from the ODACC registry. This is just a screenshot of the ODACC system if we're asked to appoint, where one of the parties have decided they can't reach an agreement mutually. I want this adjudication to move forward. I need ODACC to just, pardon me, appoint an adjudicator and get the adjudication rolling on. So again, that's the system prompting the parties. So we have an adjudicator in place. The adjudicator has had a teleconference or a Zoom call. Everybody's sitting down. They've agreed on a process. And the adjudicator is going to visit the tabs on the left side and click on process. And for all the parties, he or she is going to fill out what the process is for the adjudication, what are the timelines, what is everybody required to do so that everybody is on the same page and the adjudication can proceed with the view of getting a determination within the time frame required. The adjudication fees, again, with the process, teleconference or Zoom, the parties have either agreed on the fees that they are paying the adjudicator or ODACC has set the fees. The adjudicator is going to visit the fees tab and they are going to input either the flat fee or an hourly fee. And this is going to be visible for all the parties, and the parties will actually have to consent on the system to that fee. And then it will generate invoices for the parties, equally split for the retainer, and the parties will pay the retainer fee prior to commencing the adjudication. If it's an hourly fee, then the system will automatically put in an amount that is equivalent to 60 hours of work for the retainer. If there's less hours spent when the determination is finalized, the additional monies not utilized will be refunded right to the parties. Parties can pay their invoices right on the system through credit card and EFT, and the refunds can also be done that way as well. If the parties are not comfortable or for whatever reason don't want to do it that way, obviously payment done outside of the system can also be done and is easily done through ODACC. Next step, we have the process, we have the notice of adjudication, response, adjudicator, fee set, process set. Let's get into the adjudication. First step, claimant is going to upload their documents, depending on what process, depending on what the adjudicator has set out in terms of number of documents or which documents are required. The claimant is going to simply visit the system, go into the documents tab. The system, as you can see, notifies the claimant, your documents are due, please upload them. The claimant is going to visit the documents tab. I might also add that the respondent, when it's the respondent's time to submit their documents, they too will visit the documents tab, and they will then simply select the files that they wish to upload to be used in the adjudication, and they will upload them on the system. And as I mentioned, the respondent will do the same when it's the respondent's turn to do that as well. What I think is a wonderful addition to the ODACC system is the messages tab. This is a place where all the parties can simply message each other instead of having emails going back and forth. The idea behind the messages tab is that all parties are privy to the conversations and the communications. so that there will be no ex-parte communication. So the adjudicator will not be communicating just with the claimant, or the adjudicator will not be communicating just with the respondent. Any messages that are put on this system go out to all the parties. And it really, I feel it really ends up being quite streamlined, and everything can be found by all the parties on the system, and especially through the messages tab. Determinations, we're getting near the end. The adjudicator has received all of his or her documents, or the documents from the claimant and the respondent, busy at work, analyzing the evidence. Maybe there's an oral hearing, maybe there's not, maybe there's additional submissions. Now the adjudicator has to sit down and write a determination. That determination, as I mentioned before, the beauty of the system, you're going to get a determination really, really quickly. 30 days after the claimant files their documents, bearing in the mind that the claimant's filing their documents 5 days after the adjudicator's appointed. 30 days later, you're having a decision. People may say, oh my goodness, how does that happen? There's no way I can get this adjudication done within that time frame. Well, luckily, the Construction Act does permit extending the due date, which is set out in 13.13 sub 2. And I'm going to get into the extensions on the next slide. The determination from the adjudicator is going to give reasons for his or her decision. Again, bearing in mind, this is an interim decision that's binding unless and until there's another decision. And if you want more specifics on that, I welcome you to take a look at the Construction Act. Determination extension. The due date for the determination can be extended. It can be proposed to be extended by the adjudicator if the adjudicator decides I need more time, or for whatever reason I can't have it done within that time frame. The adjudicator can request to extend the due date by 14 days, no more than 14 days, but it needs both parties to consent to that. On the other hand, if the parties or one of the parties would like an extension to the due date, they simply go onto the system, they click on request determination extension, they put in the number of days they request the extension to be. Here, 2 days. You can see the due date is April 5th. One of the parties is requesting 2 more days, which would mean April 7th. And again, it must be on mutual consent by all parties, claimant, respondent, adjudicator. But in this case, when one of the parties makes the request to extend, it can be to whatever date is agreed upon. So they're in a different framework than the adjudicator only having the 14 days. When I look at the cases to date, by far, the majority of the cases do not request an extension. People are using this process, an adjudication, to get a determination really quickly, which I think is fantastic. People are resolving their disputes and moving on, and not letting the project or the contract sit there and it's business as usual. When the determination is completed, the adjudicator will then visit a page and input the final adjudication fee. If it's a flat fee, it's going to be the flat fee for the most part. If it's an hourly fee, this is the opportunity for the adjudicator to go through their dockets, their hourly rates, and determine how many hours did I spend on this adjudication, and submit a final fee on the system. Again, if it's less than the 60 hours put in, then let's say it's 40 hours, then the parties will each be given a refund from their retainer. And then the adjudicator will indicate if the apportionment of the final cost, is it still 50-50 between the two parties? If it's not, then the adjudicator will indicate that on the system for all the parties as well. As I mentioned at the beginning, you have your determination under the Construction Act. If one of the parties is required as a result of the determination to make a payment, they must do pursuant to the Construction Act no later than 10 days after the determination has been communicated. So again, quick. And I think that is about everything I have for you today. I know it's on first glance, it may seem like a lot. It may seem overwhelming. I think once you take a look at the website and you go through it, if you have questions, I am reachable at authority@odac.ca. I'm here to help parties and help adjudicators run the system, through the system. I don't give legal advice on your specific case. I can't by virtue of my role at ODACC, but I am here to assist in the adjudication. And as mentioned previously, please take a look at our website. It's really well laid out. It's really well designed. It helps you walk through with screenshots and tutorials and how-tos. So I really welcome you to visit the website. And I want to thank you for having me today.
Thank you very much, Elise. It was a really enlightening presentation, and it's great to see that that process is so streamlined towards just getting things done. I'll just make a note for our attendees. The presentation is being recorded and will be available on our website for future reference. So as I said at the beginning of the presentation, if you have any questions, we welcome you to add them to the question answer box for Elise. And we do have a couple that have come through. So the first question, can you explain the difference between adjudication versus mediation versus arbitration?
Well, that's a very good question. Arbitration would be a longer process where the parties are submitting documents. There may or may not be documentary discovery of documents. It will be a binding decision. It is quite similar to going to court, and it does give a binding decision among the parties, but very often it involves a lot of processes that you would see in court in terms of motions, exchange of documents. There may or may not be oral hearings. And again, you're getting a binding decision. Mediation, again, is similar. It's not binding. And it's whereby the parties are really going to sit down, present their dispute also to a third party, same with an arbitrator, a third party, neutral party, and present their disputes. And again, the process in mediation is really going to be set by the mediator, and it is a non-binding decision, and usually can be a longer process depending on the dispute that's involved. And again, with adjudication, at least adjudication, when we're talking with the Construction Act, this is adjudication. It is a decision that is involved in a very quick time frame in terms of the documents and what's involved in the process and what have you. That is going to be set with the adjudicator, and it's mandated in terms of the time frame and what's involved. And it is binding, interim binding, unless and until there is another decision.
Okay, thank you. Another question, does the form allow only one adjudicator to be suggested, or can 2 or 3 be suggested by the claimant?
Great question. So it is suggested, it's really, how do I put it? It's one at a time. So if I suggest an adjudicator and then you decide you don't like the adjudicator that I've proposed, you can then propose another adjudicator. And then I come back and I say, yes, I'll take that adjudicator, or no, but how about this one? And there can be a bit of back and forth, but it's done one at a time. I have to say, in the cases I've seen, usually it doesn't go more than, let's say, 3 back and forths, either mutually agreed. And I would say the majority of the parties are mutually agreeing to an adjudicator rather than having ODACC appoint. But that does happen in lots of cases as well.
How available are the adjudicators, and how long do they have to make themselves available once they are contacted by a claimant?
Okay, good question. If once there is mutual agreement on an adjudicator, then the system will actually send out a message to the adjudicator and will say, you've been asked to adjudicate this dispute. Do you consent? Now, obviously, the adjudicator will only consent, we hope, if they're available to do the adjudication. If they're on vacation or they have other things, then what they will not consent to take on the adjudication. And then the parties will have to find another adjudicator or ask ODACC to appoint. Again, in looking at the adjudications, I think there's only been one time that I can think of where an adjudicator was not available. But if they consent, they are available.
Is there an appeals process after the determination?
You have to check with the Construction Act. The appeals, there's a judicial review. It's in terms of your appeal or your judicial review of the decision, it's pretty strict in terms of what you can ask to change the decision. So I'd ask you to take a look at the judicial review provisions in the Construction Act.
Okay. What is the cost of the 2-day certification course by ODACC? And actually, to that, is there certain qualifications before one can apply for certification?
Okay, so good question. You can, what if anyone's interested in actually taking on the training course, two ways you can get the information. One is you can email me and I can send you some information, but Stitt-Feld Handy, which does all the adjudications, it's the Stitt-Feld Handy website has the courses available on there. Or actually, if you if you visit the ODACC website, you will get all the information in there. There is a link to take you for the training course. Again, it's a 2-day training course. Many people take it just to get more familiar with adjudication and the process. And then some take it with a view thinking, I would like to do the training and then later apply to become an adjudicator. So it's a 2-day course. I believe it's around $995. Don't quote me on that. I'd ask you to visit the website and then take the link. Once you do the 2-day training, it's 2-day, when I say in person on Zoom training. And then there's also another online component, a question and answer component done to the course as well. Once you've done those 2 components, you may then email authority@odacc.ca and request an application package from me, and I will send it out to you and then apply to become a certified ODACC adjudicator. It is an application process and they're reviewed to determine, but both based on the need of adjudicators and also on the individual, the answer to the question. It's there's evaluation questions. We asked the applicants to write determinations and a whole host of things. The minimum requirement is at least 10 years in the construction industry. That's the minimum requirement, along with other aspects which are set out in the application process.
Okay. The next question, the adjudicator registry shows a wide diversity of hourly rates from $250 to $750. Are the rates adjudicators charge related in some way to the size of the claims they are trained to review?
Good question. The adjudicators choose what rates that they will agree to do adjudications. So when we went back to the schedule of fees, some adjudicators will list, when you visit the registry, they will list if they are willing to do adjudications for the flat fees. And then they will also indicate on their profile at what hourly rate they are willing to also do adjudications at. So again, if ODACC is asked to appoint an adjudicator for a certain case, we will appoint based on the size of dispute, the amount that's involved, that will set the fee. And then obviously we will choose an adjudicator who's willing to adjudicate at that fee. So it'll list out the 3 flat fees that we have on the website. When we talked about the processes and the actual schedule of fees, from $800 to $3,000 in terms of flat fees. And then we have the hourly rates from $250 to $750. So when you're sitting down with your adjudicator, again, part of the process is to negotiate a fee, and the adjudicator, along with the parties, is obviously going to look at the size or the amount in dispute and the complexity of the case. And again, bear in mind, you don't have to agree with the adjudicator necessarily. And if you don't, if there is no agreement on the fee, ODACC will then set the fee based on that schedule fee, which is also on our website. So you can look at that more in depthly when you look at the website. It's all set out there.
Okay. When a determination is made, would this have an effect on a subsequent dispute of a similar nature within the same contract?
That's a good question. Again, adjudications, we're talking about we're only dealing with one matter. So if this is a different dispute, then it's a different adjudication unless the parties agree otherwise. So it's a single matter that the adjudicator is going to look at. Now, you may have a construction project where this is a 2-3 year project, and there may be various disputes along the way. So you are really looking at perhaps several adjudications within one larger construction project. It really depends on the case involved, but for most part, unless the parties agree otherwise, you're dealing with a single matter dispute.
Okay. Earlier, it was mentioned that adjudicators represent a diverse background. So is this diverse experiences? How do the gender and racial composition of the adjudicators compare to society's makeup? And is there something there that would give women and racial minorities comfort with the ODACC process?
Oh, that's a very good question. I think there's diverse in terms of what's on our adjudication registry, in terms of backgrounds, in terms of gender and what have you. I don't know if I can speak to how it compares in terms of society and the breakdown and the ratio out there. I think what we have to do at ODACC is we also have to choose applicants that we feel would be a benefit in terms of having great adjudicators with diverse backgrounds in many different shapes and forms on our registry. And that's what we've tried to accomplish, and I think have accomplished with our registry, our current registry.
Okay. Another question. So after the claimant files for adjudication, what happens if the respondent just doesn't answer or goes MIA or something?
Great question. The adjudication will proceed without the respondent. If the respondent chooses not to respond, and again, there is no requirement in the Construction Act for the respondent to actually file a response. I have to say, I don't think there's been an adjudication that I know of that a respondent has not filed a response, but there is no obligation. If the respondent does not respond at all, then the adjudication will proceed without the respondent, and a determination can be rendered.
Okay. Of the fee rates displayed, is that what's actually paid to the adjudicators, or does a portion go to ODACC?
A portion with the schedule of fees, the rates displayed, I think that's what you mean, the rates displayed in terms of the schedule of fees. Those are the adjudicators' rates, and then from that, ODACC gets a portion of the adjudication fee, and that is also set out on the website.
Okay. And then we have a question just about if you can provide an example of a decision made. So obviously not naming names, but maybe an example of a case that would go to adjudication.
Sure, there's been several disputes both in the commercial area and in the residential area. Just on the residential area, a number of renovations done where there's been a dispute between the owner and the contractor in terms of monies owed. Perhaps a contractor everything from dispute in terms of workmanship and feel that there's monies owed, the owner's not paying because of workmanship issues. There's been disputes because there was a contract in place for a set fee for the renovation, and the owner has decided not to pay or has said, I'm not paying the full amount because you didn't complete on time or there were workmanship issues. Commercial disputes in terms of change orders and what have you. So for the most part, I would say money's owed.
Okay, just another question. What happens in case the disputed parties, so I guess the respondent, decides not to pay ODACC?
So again, the adjudication fee is payable by both the claimant and the respondent. So I think if I understand the question, it's the respondent deciding not to pay the initial fees once the process and the fees are set. There is an option for the claimant, because the fees are initially split 50-50 between the parties. There's an option for the claimant to pay the respondent's portion of the adjudication fees to keep the adjudication going. And then when the determination is rendered, the adjudicator can make an order to have those fees repaid to the claimant.
Okay, I think that's about all the questions we have, and it's just nearing 1 o'clock, so this is perfect timing. Elise, thank you very much on behalf of OPWA for being here and for providing your excellent presentations. As you can see by the number of questions we got, everyone was keenly interested, and I think learned quite a bit from your talk today. So again, thank you very much, and thanks everyone for joining us today for our webinar.
Great. Thank you to all. And remember, I am just an email away, and you've got the website, and I'm happy to help you out. So good luck, and thank you for having me.